Professor Jessica Roberts and I wrote an article entitled "When Digital Health Tech Companies Change Their Terms of Service" that's coming out this week in Science. And in it, we describe the problem that digital health companies allow themselves to unilaterally change their terms of service.
Many people might be familiar with digital health tech. It includes all kinds of technologies like consumer genetics, period trackers, and mental health apps. And what these companies do is they allow users to collect and track their health-related information. Now, the terms of service of each company governs any disputes that might arise between the consumer and the company. And users might not be aware that most of these companies reserve the right to unilaterally change their terms of service.
So what that means is that a consumer could agree to one set of terms, but a year later, after they've been using the service, the health tech company changed those terms, and the consumer generally is stuck. What's surprising, and what surprised Professor Roberts and I, is that courts usually enforce these unilateral amendments.
But the thing that concerned Professor Hawkins and myself was that even if users read the terms of service, understood the company's privacy policies, those policies could be changed and consumers actually have very little legal recourse.
So imagine if you were selling your house and a few days before the sale took place, the buyer came to you and said, "I'm actually going to pay $50,000 less." You would think that was outrageous, but that's exactly what these companies do. They agree with the consumer to one set of terms, but reserve the right to change those terms unilaterally on their own. And so the consumer theoretically consents by continuing to use the product, but in reality, it's a very weak or thin form of consent.
In the United States, many of these digital health tech companies can actually change their terms, and in some cases, they might not even notify the consumers. They could potentially email them, but sometimes companies will just post updated terms on their websites, and consumers could be governed by a whole new set of policies that they never had the opportunity to review, and really, the only thing that they can do in response is delete their profiles.
Professor Roberts and I argue that Congress should step in and make it difficult for health tech companies to unilaterally amend contracts. For any terms that are substantial terms, we argue that health tech companies should only be able to amend the contract in the way that all other commercial agreements are amended, through actual consent. And so companies can still amend substantial terms, but they have to actually get the consumers to opt in by agreeing to those terms.